Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today will be the day I earn your subscription. For today's story, we are doing a response video to a longtime personal friend of mine, Leonard French, Lawful Masses with Leonard French. As many of you know, because I've discussed it many times, Lawful Masses with Leonard French is where I got my start as a law YouTuber. He is the OG, the first one on the platform before anyone, before Legal, before Nick, before anyone, to my knowledge, who was doing legal stuff on the YouTubes. And he is someone that I was able to get my start, at least in part, by working with him and doing things on his channel. He's a person who's been over to my house. I've been over to his house. He's my friend. And I genuinely mean that. He's my friend. We also have some differences of political opinion, which is perfectly fine, and differences of legal interpretation, which is also fine. And I saw he produced a video about this Texas letter on February the 22nd from the governor's office relating to transgender children. And it is accurate to say that his reaction and my reaction are very different. So what I'm doing today is I'm going to do a reaction to his video. And I'm doing this for a couple reasons. It's like just to show that different people can think about things differently and perhaps disagree in good faith, because I'd like to think I'm in good faith, and I know he's in good faith. I know him personally. And hopefully to say that two people who are of different political philosophies or different legal philosophies or different philosophies can have a respectful discussion about things, right? So this isn't meant to attack Leonard French in any way. It's meant for me to show some disagreement. Now, I don't know whether or not, what will happen as a result of this. I hope I won't lose him as a friend. That's not my intention. I hope that, it's not the case that, that someone would say, our views are so opposed that, we can't even have friends or discussion. But, I have a very different reaction to him. And, it's not unusual for me to comment on other people's legal videos. And I saw his video and I want to comment on it. So I certainly hope at the end of this, we will remain friends. One of his most popular, again, it's like where I got my start. I've been on videos on his channel. He's been on videos on my channel, so forth and so on, right? So we're just going to respond to this thing and do it one step at a time and see where we agree or see where we disagree. I think that might be interesting. See how two different people from two different backgrounds, two different temperaments, two different ways of thinking think about things. I know it's a lot of prelude, but I just wanted to make sure that this is, not perceived as a personal thing. This is just a disagreement of opinion. So this is Leonard French. Not a very good pause face for Leonard. I apologize for that. But let's listen to this and go from there.
This is going to be about actions taken against transgender people, and I don't want you to have a bad day if this is something that bothers you on an emotional level. It bothers me on an emotional level too, and that's why I want to bring it to you so that we can go over what's happening in Texas. On February 22nd, Governor Greg Abbott, apparently in response to a failed law, instead issued an executive order basically ordering the Department of Family and Protective Services to treat transgender children as having been the victim of child abuse. In other words, notwithstanding any actual child abuse, if a family, parents, doctors, counselors support a child's gender issues, that's child abuse, according to Texas. The Office of the Attorney General has confirmed that a number of so-called sex change procedures constitute child abuse under Texas law. The Texas Department of Family and Protective Services, DFPS, is...
I apologize. The video was very, very low to start. The audio was very low. So let's just start over because I don't want you to miss anything he says. So we'll just start over from the beginning, and it'll be a little sloppy on the edit, or not-edited because it's live. So it'll be a little sloppy, but let's make sure that, and I'll even put closed captioning on. I mean, the closed captioning is presumably automatic, but that way, it'll at least be as close as YouTube gets. So let's start this over.
Okay, trigger warning for this next story. This is going to be about actions taken against transgender people. and I don't want you to have a bad day if this is something that bothers you on an emotional level. It bothers me on an emotional level too, and that's why I want to bring it to you so that we can go over what's happening in Texas. On February 22nd, Governor Greg Abbott, apparently in response to a failed law, instead issued an executive order basically ordering the Department of Family and Protective Services to treat transgender children as having been the victim of child abuse. In other words, notwithstanding any actual child abuse, if a family, parents, doctors, counselors support a child's gender issues, that's child abuse, according to Texas.
Which is okay. So then so one of the primary questions, obviously, is like, what is child abuse? That's a like, you have to start like with first principles. Obviously, with something like this, because like, you know, notwithstanding whatever else might be child abuse. So I'll rephrase it slightly. You know, notwithstanding whatever else might be child abuse, Leonard French says the governor's attempting or has directed that something else shall now be considered child abuse. Now, of course, we want to go to the governor's exact words, right? And exactly what they're saying is or is not child abuse, so that we can comment intelligently about what the governor's saying. So let's read on and see what it says. Or listen on, I guess, in this case.
The Office of the Attorney General has confirmed that a number of so-called sex change procedures constitute child abuse under Texas law. The Texas Department of Family and Protective Services, DFPS, is responsible for protecting children from abuse. So the governor, Greg Abbott, hereby directs your agency, the DFPS, to conduct a prompt and thorough investigation of any reported instances of these abusive procedures in the state of Texas.
So I would note right away that, in my humble opinion, that Leonard French mischaracterized what the letter says, right? It's not right, because he said initially that it was, we're going to investigate any doctors or parents who are supportive of transgender children. And the letter from the governor says it's much more narrowly focused. It says we're going to be investigating any procedures, sex change procedures that are taking place. So again, this is much more narrow. This isn't, at least in its own terms, isn't saying we're going to investigate parents who teach their children about transgender issues. It's not saying we're going to investigate parents who are trying to read from transgender texts or teach their children about transgender issues, or, you know, support them in some sort of other respect, right? In terms of like just being generally supportive or encouraging. We are not doing that. We are targeting certain procedures, medical procedures, physical procedures, which might constitute the practice of medicine. And there are regulations concerning the practice of medicine, and especially when it relates to children, because of issues, obviously, that pertain to children and their ability to consent. Now, in some cases, parents can consent for their children, but not in all cases. And because there's some impact to children that might be necessary for the protection of children under regulations of various state laws. So, like, the first thing we're doing is we're only investigating the sex change procedures, not like generalized supporting of transgender children. So we've moved from a much broader claim to a much more specific claim, I think is important to know.
The Office of Attorney General opinion number KP0401 makes clear that it is already against the law to subject Texas children to a wide variety of elective procedures for gender transitioning, including reassignment surgeries that can cause sterilization, mastectomies, removals of healthy body parts, and administration of puberty-blocking drugs or supraphysiologic doses of testosterone or estrogen.
Okay, so yeah, what are we trying to investigate? Again, are we trying to investigate every way a parent might, are we trying to investigate every way a doctor or a parent or a teacher or a therapist or a counselor or a social worker or whatever might try to support, encourage, build up, affirm, teach, educate with respect to a positive outlook in some sense when it relates to transgender issues. No, we're not trying to do that. We're not trying to do that. We're not trying to do any of those things in this letter. In this specific letter, we have taken note, the Attorney General has already taken the opinion that as a matter of Texas law, there are medical procedures that are not permitted when it comes to children. Elective procedures, one would note. Elective, by the way, in this context is an important word, obviously, because if it's medically necessary, in some sense, it would not be elective. And there might be medically necessary reasons to conduct some things that look like this, right? I mean, for example, various cancers can, come in place in weird ways sometimes, right? The body's a weird thing. Or it might be necessary to take some fairly extreme procedures, but we're talking about elective procedures. Procedures that include reassignment surgery, removal of healthy body parts, and administration of puberty-blocking drugs or super physiological doses, which is to say more than your body produces, of testosterone or estrogen. And not necessarily all, right? Because the term super physiological might be further defined in the relevant OAG letter or in the code. So I'm not even sure that it necessarily means all like administration of estrogen or all administration of testosterone, but it refers to amounts beyond certain levels of whatever that is. So that's what that's what we want to investigate. These are already banned under Texas law. We'd like you to investigate if it happens in violation of Texas law. We'd like you to investigate the breaking of the Texas law. Okay. I mean, all right.
These are things that would normally be between the child and the family and the doctor, and now Texas is inserting itself into these medical decisions.
Okay, well, if we're going to go down that road, right? So, okay, it depends how we're going to go about this, right? So it's like, okay, so are we going to take an absolute position? Are we going to take an absolute position that it's always wrong for the government? So let's assume that let's assume the child actually wants it. So we'll make this easy. We'll make this easy, right? Let's assume the child actually wants it. Let's assume the parents actually want it. Let's assume the doctors actually want it. Okay? So there's no conflict, right? Then because on top of that, we could get into conflicts between parent and child because parents can sometimes overrule their children when it comes to medical things, right? Their child doesn't necessarily want a shot. Some children are afraid of shots, for example, right? Child doesn't want it. The parent does want it. The doctor wants it. This is, by the way, for all kinds of shots. I'm not even talking COVID. I'm just talking all kinds of vaccines, all kinds of shots, right? It's a bit of a cliche that kids are afraid of it, right? So we could get into the issue of whether or not parents along with the doctor should be able to overrule the preferences of a kid, right? So we could get into that issue, but let's make it easy. Let's assume the kid's also on board. Okay, so the kid's on board, the parents on board, the doctor's on board. The question is there a role for the state to say no? Is there a role for the state to say no? Should the state, in any circumstance, be able to interfere in that proceeding? And, it shouldn't take a lot of, and if anyone is watching this and screaming, never, they should never intervene. I'm like, really? Really? It's like you're not thinking hard enough. You're not thinking hard enough, right? If you think never. If you're thinking, well, they should be allowed to intervene, then the question becomes like, okay, well, is this one of those occasions? Right? I mean, I'll give you an example from the other side of the aisle, right? I'll give you an example from the other side of the aisle. There are parents who perhaps with their child's interest might be interested in undergoing psychological counseling as it relates to gender identity. Perhaps having some open questioning when it relates to that might, in some senses, suggest to the child that perhaps that, you know, conformity with a biological gender might under some circumstance be good. Should the state be allowed to intervene with that? Should the state be allowed to intervene with this? These are good questions. And here the Texas has taken the position that yes, in the practice of medicine, when it comes to children, particularly because these can be fairly permanent changes in many circumstances, that perhaps they should not be permitted when it comes to children. So, you know, should the state of Texas be allowed to make that decision, yes or no? And should they be allowed to make this decision and not other decisions, or allowed to make other decisions and not this decision? And if so, what is the principled reason for those distinctions? It's always helpful to think these things all the way through.
Texas law imposes reporting requirements upon all licensed professionals who have direct contact with children who may be subject to such abuse, including doctors, nurses, teachers, and provides criminal penalties for failing to report such child abuse. So they've gone from investigate because it could be child abuse to now just flat out calling it child abuse in this second paragraph.
Correct. They're flat out calling it child abuse. Correct. Right. They're flat out calling it abuse. Texas imposes requirements on all licensed professionals with children who may be subject to abuse. Correct. Right. Mandatory reporting requirements. This is nothing new. And again, I mean, this is not like a new concept. So Texas believes that, again, what is the nature of the child abuse? What is the nature of the child abuse? According to Texas, the elective procedures for gender transitioning, reassignment surgeries that cause sterilization, mastectomies, removal of healthy body parts, administration of puberty blocking drugs, or super physiological dosages of testosterone or estrogen. That is the nature of what they think is abusive. It's regulation of the practice of medicine. It is, you know, these things may have permanent impacts on children who don't have necessarily the ability to understand what's going on. Texas is of the opinion that these kinds of elective medical procedures may be harmful to children in their judgment. Pressing on.
There are similar reporting requirements and criminal penalties for members of the general public. Texas law also imposes a duty on DFPS to investigate the parents of a child who is subjected to these abusive gender transitioning procedures. So again, we've gone from it could be child abuse to it is child abuse to it's abusive. It's just taken 3 paragraphs to just transition from the potential for child abuse to now it is definitely abusive to even think about it. And on
well, that's not exactly quite right. Right. Earlier in the letter, we talked about, like, generally speaking, we want you to investigate what is abusive. And then we have to talk a little bit about what is abusive, right? So we've moved from, we want you to investigate generally any sort of incidents that relate to child abuse. And now we have to tell you specifically what it is we want you to investigate, right? What is child abuse? Well, we have to define it. So, like, yeah, we're defining this as child abuse as far as we're concerned. The Department of Family Services is supposed to investigate parents of children who subject these abusive gender transitioning procedures, right? Not support, not encouragement, not teaching, not education, not procedures.
Other state agencies to investigate licensed facilities where such procedures may occur. To protect Texas children from abuse, DFPS and all other state agencies must follow the law as explained in the opinion. Now,
which is also, like, just generally true. Of every state, probably ever. The Attorney General of the state is the chief law enforcement officer of the state. They're the head of the law enforcement by definition. And so when the Attorney General comes out with a legal opinion, every state agency has to follow those opinions. Every apparatus of the executive branch, which is what agencies are, right? They have to follow the opinion of the Attorney General because he's the chief law enforcement officer of the state. And he's like, well, this is my legal opinion. I'm now giving you direction as the chief law enforcement officer of the state, I'm now giving you direction, agencies who are all subsidiary to me definitionally, to follow my interpretation of the law. Yeah, that's pretty normal.
Now, why would you institute an executive order? Because it's easier than changing the written law. So I'm assuming that because he's issued an executive order, the law actually doesn't say this.
Well, no, he says it does say that, right? Because the Office of the Attorney General has written a letter, or written an opinion. This whole thing is referencing an opinion of the Attorney General. The Office of the Attorney General in Texas has written an opinion letter saying that, in their opinion, certain procedures are banned under current law. Now, it also seems to be true that Texas was trying to make this even more explicit in its law, right? The legislature maybe wanted something a little bit more explicit. So they were considering some more explicit language. And apparently that didn't proceed. But, it's not necessarily the case that just because that legislation failed doesn't mean it wasn't already covered by the current law, right? You can have multiple different things that speak to something, right? Another good example, by the way, just like generally speaking about this concept, about like a legislature failing and it still being law, would be like codification of common law. Some states codify their common law more than others. And some states don't really like codification. Codification is just a fancy name for when you put it in a statute book. Like when the state legislature actually passes it as code law, codification, right? So there's a whole bunch of law that isn't in the code, right? There's common law is not in the code. In some states, in fairly serious ways, like some states, murder charges are still common law in some states, in some circumstances, right? So there can be some fairly serious things that are still common law. So just because the legislature doesn't pass something, like, so say someone wanted to codify the common law, if they don't pass it, it doesn't mean it stopped becoming the common law. It just means that it wasn't codified. So it doesn't quite go hand in hand, that just because the bill failed means that the action was already legal. It's like, well, we wanted something more overt, the more overt thing, but the Attorney General said, under my opinion, it's already illegal. And now the governor is issuing an executive order directing the executive agencies to follow the opinion of the Attorney General. So, that's, what you would expect to happen.
And the ACLU agrees. On March 1st, the ACLU sued on behalf of one of the first victims of this law.
I love how we define them as victims. We have Leonard and I, again, Leonard is my friend, but Leonard and I have a very, very different understanding of what a victim under this law looks like. This goes to our differences, which I respect Leonard for his differences, but we have difference of opinion of what a victim looks like in this situation. And maybe the ACLU is right. I don't know. I haven't looked into the depths of this. I don't even know. I'm not even necessarily claiming, by the way, the Attorney General's opinion is legally correct. I don't know. I haven't looked into it. All right? I haven't made the claim that it is correct. I've made the claim that's the opinion of the Attorney General. I've made the claim that as the opinion of the Attorney General, it's to be followed by the executive branch. I've pointed out the governor has said to follow the opinion of the Attorney General, who is the chief law enforcement officer, right? But of course, that doesn't mean the governor is right, nor does it mean that the Attorney General is right? The governor or the president can issue all kinds of executive orders that are crap. The Attorney General can issue all kinds of orders that are crap. We have legal disputes over that. So I'm not saying that, the Attorney General is right. I am saying that the governor just said, the Attorney General says this is the law until it's overturned. That's the law. In Texas, as far as the executive agencies are concerned, because again, they are, subject to the executive, which is the governor of the state. So, it's, and the Attorney General. So, okay, let's press on.
These plaintiffs are maintaining their anonymity as John Doe, Jane Doe, and Mary Doe, the child, as well as their doctor, Dr. Megan Mooney. The ACLU and Lambda Legal have asserted basically that these laws are illegal, and they've asked for a temporary restraining order, temporary and permanent injunction against Greg Abbott, the DFPS, etc., against enforcing these laws.
Okay,
I'm
why
going
is
to
it
cover just
illegal?
a small part of this because this is a 68-page complaint, and then we'll go over what has happened afterwards, which is the not an ending, but it's a happy non-ending, and we'll go over that in a moment. After Texas failed to pass legislation criminalizing well-established and medically necessary treatment for adolescents with gender dysphoria.
Now, right away, we see a conflict, right? Because the lawsuit claims medically necessary. If it were truly medically necessary, it wouldn't be an elective procedure. The whole concept of an elective procedure makes it not medically necessary. So the right away, you see that the lawsuit has a very different understanding from apparently the opinion of the Attorney General as promulgated by the governor about what constitutes medical necessity. And I'm not even sure how you would necessarily go about saying it's well established either. But pressing on.
The Texas Governor, Attorney General, and Commissioner of the Department of Family and Protective Services attempted to legislate by press release.
No, not exactly. They attempted to regulate through the Office of the Attorney General, who issued a legal opinion, which is consistent with many states issuing a legal opinion. And then the Office of the Governor, as the executive, as the head of the executive, issued an executive order to the rest of the executive, noting the opinion of the Attorney General, who is the chief law enforcement officer, and told the rest of the executive branch that as head of the executive, he was directing them to follow the opinion of the chief law enforcement officer of the state. Not quite press release.
Governor Abbott's letter instructed DFPS to investigate the families of transgender children, which is entirely without constitutional or statutory authority. And despite this, the commissioner nonetheless issued a statement directing DFPS to carry out the governor's wishes and agreeing to follow a non-binding legal opinion that did not change Texas law.
Well, I mean, yes, by definition, the opinion of the Attorney General can't change the law. Right? The opinion of the Attorney General can't change the law. That's not possible. So it's like you just told me something that doesn't even make sense. So it doesn't change the law. I know that. Right? He's telling me what the law is. Now, apparently it's a non-binding opinion, but the governor says, let's follow it. I'm not sure, incidentally, in Texas, what makes it non-binding versus binding. I'm not sure what that distinction is. The governor, of course, as the authority of the state, can make it binding because he's the chief law enforcement, he's the chief executive. So he can, as chief executive, tell the executive branch how to, be executive. Yeah.
The governor has circumvented the will of the legislature, and in doing so, he and the commissioner have run afoul of numerous constitutional and statutory limits on their power.
Maybe.
When an executive goes outside of their power, we call that ultra vires in Latin. You might see that term coming up. The defendants have, without constitutional authority, acted to create a new definition of child abuse that singles out a subset of loving parents for scrutiny, investigation, and potential family separation.
Whether or not they're loving or not, doesn't necessarily make it child abuse or not. I mean, again, I wouldn't be able to say for absolute certainty, but there might be some parents who, at least in their own mind, are loving, who nevertheless would engage in behaviors that society deems to be child abuse. Now, we could say that that's not really loving, but then again, we're back where we started, right? It's like, well, we say, well, that's not really loving because it's child abuse. So now we're just back to where we started of defining child abuse. So like, I'm trying to get around this, the issue of the snake eating its tail, right? I'm trying to get around that issue by separating the concepts. So I'm at least positing the possibility that a loving parent could theoretically engage in behavior that would be child abuse, because otherwise it's just child abuse all over again, and we're eating its own tail. And in that situation, the fact that they're loving would be irrelevant, is my point, right? So even assuming the predicate that they are loving parents and they're engaging in child abusive behavior, do we care that they're loving parents? I mean, no, presumably if they're engaging in child abusive behavior, right? We don't care that they're loving parents. We don't care that they're good-hearted people or the moral people. This is all, again, assuming that you can separate the concepts, which is necessary, because otherwise you're just saying child abusers are child abusers. right? If you can't be a loving parent who's a child abuser, then you're just saying child abusers are child abusers, and you're eating its own tail. So I'm just trying to separate the concepts. I hope this is clear why I'm doing this for semantic reasons. I have a feeling that I'm going to be massively misinterpreted, and people are going to come up with a view that I'm saying that loving parents beat their children. I'm not saying that. Are we all paying attention to what I'm trying to say? I'm trying to say let's treat these as two potentially separate categories. So by having them as separate categories, they each independently will have meaning, right? They must be separate to have meaning. On the one hand, loving parents. On the other hand, child abusers. For these concepts to both be independent, they must be at least possibly separable. Otherwise, they're the same thing. So either you're saying, yes, they are the same thing, or in which case you're just saying child abusers are child abusers, or you're saying they're separable, in which case it's possible to be one and not the other. We all get this? Do we understand why we're doing this grammatically? I feel like I have to explain this in really strong depth because people sometimes don't understand this. Moving on.
Their actions caused terror and anxiety among transgender youth and their families across the Lone Star State, and singled out transgender youth and their families for discrimination and harassment. What is more, the governor's, attorney general's, and commission's actions threaten to endanger the health and well-being of transgender youth in Texas by depriving them of medically necessary care while communicating that transgender people and their families are not welcome in Texas.
That is not what the letter said. It didn't say anything like that. First of all, it didn't say medically necessary. Second of all, it doesn't say they're not welcome in Texas. It just says not so much with the elective surgery.
The governor has also declared that teachers, doctors, and general public are all required on pain of criminal penalty to report to DFPS any person who provides or is suspected of providing medical treatment for gender dysphoria, a recognized condition with well-established treatment protocols. And
I'm not sure that gender dysphoria, for all its well-recognized nature, because it is in the DSM, you know, it is in the DSM as a mental condition in the DSM, but I'm not necessarily sure that well-established treatment protocols for the children necessarily includes some of these things.
DFPS has started investigating families for child abuse based on reports that the families have followed doctor-recommended treatments for their adolescent children.
Again, I just want to point out here, are we saying that as long as it's doctor recommended and the parents are saying okay, that we're cool with it? If a doctor's willing to say, and we don't even have to go to bad faith. We could go to good faith. If a doctor in good faith is willing to say, I recommend this medical treatment, and the parents say they're on board, are we saying that the Department of Family Services should never investigate that? You know, does that logic extend to conversion therapy, for example? If a doctor recommends conversion therapy in their medical opinion, and the parents are on board with it, should that be investigated or not? Which one should be investigated, which not? When should the state step in, even if the doctor and the parent are both on the same page? All right. So it's like, yeah, the fact that the doctor, the point here, by the way, the point here is to illustrate the concept that the doctor's recommendation and the parent's consent may not necessarily be sufficient. If it is sufficient, then, you know, where there's a lot of other things we're not investigating, and maybe we don't want that result. So maybe we need to think about it harder.
The actions of the governor, the commissioner, and DFPS violate the Texas Administrative Procedure Act, are ultra vires, and therefore invalid, violate the separation of powers guaranteed by the Texas Constitution, and violate equality and due process protections guaranteed by the Texas Constitution. Plaintiffs ask the court.
Now, your problem there, of course, under the Texas state constitution, is obviously that has to be interpreted as a matter of state law. So when you're looking for this, for example, if your source of authority is the Texas state constitution, then whatever might be true of due process or equal protection for the federal constitution may not necessarily be true for the state constitution, because obviously it's a different legal document with different courts interpreting it. So
to enjoin these violations of Texas law and of plaintiffs' rights and immediately return to the status quo ante, the status before this was implemented.
All right, let's skip
accepting
ahead.
of her, giving her the space to express herself. And from a very young age, Mary Doe has expressed herself and behaved in a manner that does not conform with the stereotypes associated with the sex or gender she was designated at birth.
Okay, this is a good case in point, right? This is a great case in point. From a very early age, Mary. Let's just accept the premise. From a very early age, Mary Doe has shown behavior that's inconsistent with their assumptions and presumptions of their gender. All right, let's imagine two alternate universes. Okay. We can do this at the same time. We're big boys and girls, right? We can imagine two alternate universes, right? So the predicate is, from a very early age, Mary Doe has expressed behaviors and interests that are atypical or against the stereotypes associated with her gender, okay? Let's imagine two alternate universes. In universe number A, Mary Doe's parents go to a doctor, and the doctor says, you know what? I note that they're acting inconsistent with their gender. I recommend gender conformity therapy. I recommend that they go to a psychiatrist who will be in a position to tell them more about how they can, what kinds of behaviors are appropriate for their gender and what are not. And also, we can explore some medical solutions that will help them with some of the more egregious expressions of their physicality. So we can look into some medical solutions as well. And so then they go pursue that road. That's universe A. In universe B, Mary Doe's parents go to the doctor, and the doctor says, hey, I note that your child is acting inconsistent with the presumptions of their gender. And what I'm recommending is that we help them steer into that skid. You know, I'm recommending that we begin with psychiatrists and psychologists who will help explore this side of their behavior. And ultimately, we can start thinking about some gender reassignment surgery, which will help them live a life that's more consistent with their behavior. Okay, so I propose, in both universe A and universe B, the parents say yes, because they're very amenable parents. So in both universe A and universe B, the parents say yes. Here's the question: should the state intervene? Should they intervene in either A or B? A and B, neither A nor B. Please show your work. Please show your work about why the state should intervene in one and not the other, if that is your opinion. Just, show your work. Pressing on.
Supported and accepting of her, giving her the space to express herself and explore who she is. She has been under the care of the same pediatrician most of her life. Her pediatrician diagnosed.
By the way, in case you want me to show my work on this, about why I would think it's different, one of them involves physical surgery. Right? One of them is talk therapy, and one of them involves physical surgery and potentially permanent changes, and changing hormones and chemicals, and lopping body parts off. So to my mind, that is a distinction with a difference, but maybe that's just me.
Diagnosed her with gender dysphoria and referred the family to other medical professionals who likewise confirmed that Mary suffers from gender dysphoria. The family has done research to educate themselves about gender dysphoria and its treatment, and connected Mary with youth support groups that would permit them to have discussions as a family.
No one has a problem with that.
Following Mary's diagnosis, Mary's doctors recommended that she be provided with medical care to treat and alleviate her gender dysphoria. This care has included the prescription of puberty-delaying medication and hormone therapy to initiate puberty consistent with her female gender.
Now let's imagine alternate paragraph 73. Let's imagine alternate paragraph 73 as we're imagining our two alternate hypothetical universes. Following Mary's diagnosis of gender dysphoria, Mary's doctors recommended that Mary be provided with medical care to treat and alleviate the gender dysphoria. This care has included the prescription of puberty-infirming medication and hormone therapy to initiate puberty consistent with his male gender. Should the state intervene in one? Should the state intervene in both? Is one child abuse? Is one not? Right? Again, if you were asking me to differentiate before, I think there's a bit of a difference to my mind of therapy that affirms versus therapy that disaffirms. Because one is going along with the gender and one is going against it. And those are not equivalent. But, yeah.
Hormone therapy to initiate puberty consistent with her female gender. In consultation with these doctors and after extensive discussions about the benefits and potential side effects of this treatment, the family jointly decided to initiate treatment for Mary's gender dysphoria. This treatment has been prescribed by Mary's doctors in accordance with best medical practices and what the family understands.
With what they believe are best medical practices. What about what a different doctor believes are best medical practices? How about disagreement of best medical practices? Is this up for everyone's individualized decision, or does the state have a regulatory role?
Will be the best course of action to protect her physical and mental health. And then we have a cat.
We can skip cat time.
Worried about having to undergo a puberty that would result in permanent physical characteristics not in alignment with her female gender.
That's so deceiving, right? It's like, oh, we're worried about her having to undergo a parent. I'm saying the lawsuit's not deceiving. I'm saying the lawsuit is deceiving, not Leonard is deceiving. In case there's any confusion, right? The puberty will bring about physical changes that will result in permanent changes, as opposed to the medical procedures that you are recommending.
Being able to be affirmed as who she is, including through the course of treatment prescribed by her doctors, has brought Mary significant relief and allowed her to thrive.
For the moment, should we talk about the rates of people changing their mind and people transitioning and detransitioning, and maybe the fact that this child who's under the age of 18, maybe not in a position to determine for herself what life-altering changes would be good for her / him / whatever at this point in their life? Maybe not so much.
The issuance of the Paxton opinion and the Abbott letter, followed by DFPS's implementation of these to investigate the provision of medically necessary gender.
Again, you gotta love the lawyers, right? They call it medically necessary. Like, they'll just keep calling it medically necessary because they say medically necessary. The letter says, elective. Again, a dispute may be about what is medically necessary here. Is it up to the doctor to determine what's medically necessary? Is that the end of the analysis? So as the doctor says if the doctor says the gender affirming treatment or the gender conforming treatment is okay, then that's the end of the analysis. Is that where it stops?
Affirming care as abuse has wreaked havoc on the Doe family. The family is now terrified for Mary's health and well-being. And you might think this is one level of bad, but now it gets worse.
I don't think it's one level of bad. See, this is where Leonard and French and I have a difference of opinion. I don't think it's one level of bad. Right? I think that this is a person under the age of 18 and they're proposing giving drugs that will inhibit puberty, which has unclear long-term ramifications. And it's interrupting a natural biological process that is normal and typical. It's not like an abnormal process. So, so it's like, okay, all right.
Jane Doe works for DFPS. On February 23rd, 2022, following the issuance of that Greg Abbott letter, Jane communicated with her supervisor at DFPS to seek clarification of how the Abbott letter would affect DFPS policy. Such clarification was important for her family as well as her ability to perform her job at DFPS. That same day, just...
If you have a job at DFPS, you have to do your job. So, okay. And then it goes on to say apparently here that they informed them that they'd be investigated to see whether or not they were violating the law as determined by the Attorney General. You went to your boss and be like, hey, I'm doing this thing that the Attorney General just said is illegal. And they're like, well, we have to investigate you to see whether or not you're doing the thing that's illegal as determined by the Attorney General. CPS interviews them who were accompanied by counsel. What else happened?
February 25th, DFPS
and Mary Doe has her own counsel.
Services visited the Doe's family home to interview them. The CPS investigator interviewed Jane and John, who were accompanied by counsel, together while he interviewed Mary Doe, who was accompanied by separate counsel, which is what you do. It's normal for the child to have their own attorney in case the parents are abusive. You don't want...
It's not atypical. I don't know how common it is, but it can be done. You know, it's guardian ad litem, if you want to use the proper terminology, for the kid to have their own lawyer, and there's a whole programs for that.
Doe's medical records, which the Doe plaintiffs refused to sign. The CPS investigator disclosed that the sole allegation against has been traumatized by the prospect that she could be separated from her parents, lose access to the medical treatment that has enabled her to thrive.
Well, you can tell that someone who really, really has a hard-on, to use perhaps exactly the right word, for the medical transitioning treatment wrote this because, like, you know, it's taken a noticeable toll on her. Parents are observed how they're typically joyful and happy is now moody or stressed and overwhelmed. I mean, it's like, you know, I don't know. I don't know what's really going on in Mary's head, or whatever her name is, Jane Doe or Mary's head. I don't know what's going on in her head, and neither do you. And I'm pretty sure she doesn't necessarily know. And I don't know her parents necessarily know. I'm not sure if there is anyone who knows. And maybe we just want to avoid, you know, the medical stuff when you're really, really young. You know, that's, again, just me. Let's see if there's anything else I want to do here. Okay, so we got the plaintiff, who is a doctor, a licensed psychologist who thinks this is the bee's knees. Suffer irreparable harm, blah, 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 blah. Now, where is this? Oh, so the TRO was granted. Okay. So, all right. So the judge ordered a TRO, which, all right. So let's take a look at this in a little bit in terms of the TRO. Now, you can know right away, like, where this is going, right? Because, like, the district judge issued a TRO. Guess what happens next, right? Appeal to the Fifth Circuit. What do you think the Fifth Circuit's going to do, right? But let's take a look at this judge's TRO thing.
So skipping ahead then, there is some good news in the temporary restraining order.
All right, so set forth, suffer irreparable injury, blah, 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 placed on administrative leave, the stigma being attached to, blah, blah, blah. If she does not comply with the order, she could face immediate criminal prosecution. Referring to the psychiatrist, and yes, that would be a possibility. These wrongful actions cannot be remedied by award of damages. I mean, you know, fair enough. I mean, to some degree, that's true. And then, so there's a TRO for the moment. But I don't know how long that's going to last. I'm not going to do any more of Leonard's video because we can just be talking about it. We'll follow this case. But yeah, so TRO, temporary restraining order, ex parte order. It's a little unusual to issue because they're viewed very, very skeptically. It's the same 4-part standard for injunctions we all know and love that we've discussed many, many times, right? You know, irreparable harm, likelihood of success, you know, harm to the respective sides, what's in the general public interest. Is your 4-part test you all know and love. And so the judge here says, well, there would be immediate harm because some of this can't be remedied at law. So issue the TRO. Kind of makes sense. I don't think the TRO is long for this world. I see an interlocutory coming to the Fifth Circuit near you, and I see the Fifth Circuit reversing this, is what I think is going to happen. Is this in district court Yeah, this is in district court. Is this in U.S.? No, this is not in U.S. District Court. This is in the District Court of Travis County. Yeah, so this is in state court. So this may or may not be going to the Fifth Circuit Court of Appeals. So normally you're looking at a review from this would probably, so this is Travis. So this would be the second Court of Appeals in Fort Worth that would hear this, but you still might see you might still see this federal court get involved on this, perhaps on some issue. Well, it's state law, so who knows? We'll see. We'll see. We'll follow it, but I don't know that TRO is long for this world. In any event. So yeah, God Gun Games aren't I and Leonard French acquaintances? Yes, we're friends, or we at least were at the start of this stream. Maybe he'll disown me. I don't know. We'll find out. But yeah, Leonard French and I have just vastly different opinions on this, right? We have vast difference of opinion. Leonard French is of the opinion that, that the failure to provide this medical care that includes puberty blockers and possible physical surgery is the failure to do it is child abuse. I'm of the opinion that the doing it is child abuse. We have a very, very different of opinion. So whether or not he wants to say we're no longer friends or acquaintances because he can't tolerate me and my wrong think, I don't know. I consider him my friend despite the fact we disagree. We disagree. And that doesn't prevent him from being my friends. We can agree on other topics, but obviously I can't force him to be my friend. So I guess we'll find out. Yeah. So hopefully I won't lose him as a friend where I say, Leonard, I just disagree with your opinion. I don't think that kids, even with the parents and the doctors, should be allowed to make these decisions. I just do not agree. When you're over the age of 18, do whatever you want. You're an adult. But until then, I don't think so. I just don't think so. And I think Texas is within the bounds. Now, I will point out, for what it's worth, right? Everything I just said is a policy position. Right? Everything I just said is a policy position. So in terms of the law, I don't know. And I still don't know. The TRO talked about irreparable harm, which is understandable because it's on an injunction, which is an equitable form of remedy, not a legal remedy. But whether or not what the governor did or what the attorney general did is legal, I don't know. It might be. It might not. As a matter of policy, it doesn't bother me. It doesn't bother me as a matter of policy. But if you came to me as a judge, I'd interpret it legally because that's how I roll, and I don't do my own policy, right? So I'd go look at the relevant law and determine whether or not it makes sense. And if the governor's wrong or the attorney general's wrong, I have no problem ruling against them either. Because the attorney general and the governor are sometimes wrong for either party, nationally or federally, nationally or state level, right? So if they're wrong, they're wrong. I don't know legally. On a matter of policy, I think they're right. But on the law, I don't know. And judges do law, not policy. So, but you can go look at it. But I did notice that the complaint seemed, at least from our brief read, our brief recitation, seemed a lot more baked on the sort of moral or outrage of it all, right? It seemed more based on the she's thriving, she's doing really good, this is going to hurt her, she's not going to be thriving as much, this won't be really good for her if this happens. And taking all that as true really doesn't go a long way towards the legal argument, right? The legal argument is I really wish to be able to do this thing. It really hurts. It really is harmful to me. I can't do this thing. It's really helpful when I can do this thing. Doesn't necessarily go all the way to the legal argument about whether or not you can do that thing. So, yeah. So all that stuff. Zodiac says, I think a bunch of judges rule based on policy. I don't agree. I don't necessarily disagree with you, but I'm just telling you what I think, right? Everything's my opinion. I don't think judges should rule on policy. I think judges that rule on policy, whether right wing or left wing, are bad. I don't think judges should rule on policy. Policy is your last tool as a judge. It is your last tool as a judge, is policy, not your first tool. And if you have anything else to do with, if you can do it on any other grounds, you don't go to policy. At least in my view, policy is your last tool in the box. You should avoid it because policy is for the legislature. It's for the political branches, not for the courts. So you should avoid policy wherever possible. Yeah. That's what I think, at least. Matova says, you really think the child made a decision in the case? The line the parents knows at a very early age was the giveaway. This is pushed by parents. I don't know. I'm not taking any position on the ultimate truth of that. That's a fact-based question, right? That's a fact-based question. And for the purposes of a complaint, you typically assume that the complaint is true, right? Especially on a preliminary, like a motion to dismiss. Not so much maybe for TRO, but like at this stage of the proceeding, I'm not making fact-finding questions. So I'll just assume it's true and press on. Reddy, you've said, have Ken's counseling couch on so you can yell at each other. Ken's counseling couch was unwilling to appear on video, and so I refused to have him on. He refused to be on video, and so I refused to have him on. I respect his choice. I'm not going to impose on him. He has a right to privacy and all the rest of it. But if I'm going to go on video and with my face and my voice, if I'm going to go on video and I'm going to express an opinion, then I'm going to insist that whoever I'm talking to do the same, right? If someone is so afraid of being canceled for having the wrong opinion or something or whatever, like, I respect them, but they're not going to appear on my program, so that's not happening. So that is not happening. Anything else before I go off? I'm going to try to make an effort, I think, to start streaming like the hour before Nick goes on as like a warm-up act or something. I'm not saying I'm necessarily committing to that, but I'm going to make a try. I'm not necessarily sure I'm going to do it tonight because I'm a little tired. I visited Attorney Tom, by the way, yesterday, and so I'll be on his channel soonish because I was live streaming with him last night from his blimp, and that was fun. So looking forward to that. Yeah, Ken's counseling couch says I'm not on video because I was docked and people harassed me and made disgusting allegations about me. Okay, I mean, fair enough. If that's your reason, I respect your reasons, and I know you respect mine. So fair enough. I'm not trying to dox anybody. I'm just setting terms for appearing on my channel. If I'm gonna look into the camera, if I'm gonna look right into the camera and I'm gonna express an opinion with my face, I don't think it's too much to ask that other people do the same thing. If we're going to have a discussion about a sensitive topic like this, it's like, I want you to, be on camera and stand by your words. If you're not willing to do that for whatever reason, I respect that, but, that's the bottom line. How short was he? That's funny. All right, yeah, I'm gonna sign off for now, man. Nick's fluffer, that's cute. I'm going to sign off for now. If you've enjoyed this, please remember to give it a like, comment, subscribe, do all the YouTubey things. I need to publish my regular video for the day, so I'm going to sign off, and then I'm going to immediately publish a video. I'm just going to publish something. I'm not even sure what it is, but I'm going to go into the YouTube backend and make a few clicky clackies, and so there will be a new video appearing on my channel in about 5 minutes. Something exciting to look forward to. But until then, my friends, I hope all is well. Cheers and goodbye.